Hello and welcome back to the Legal Trifecta, the podcast where you can gain the legal insights of a senior attorney and an ambitious paralegal. And you, our listeners, complete our trifecta by bringing in your questions and curiosity each episode to enrich our conversation. Without further ado, it's my pleasure to introduce you to Sandy. All right, Sandy, how are you doing?
I'm doing fine.
Awesome, yeah. You know, last episode we talked about the eclipse, and this episode we're kind of getting into a lot of topics, but mostly about Elon Musk's case. So when you brought this up, I thought that was really interesting. It's in regard to pro hac vice. I hadn't heard that term before. So can you give us a little bit of context on what that is and how that applies to Elon Musk's case?
Pro hac vice is an outgrowth of the fact that each state regulates attorneys within that state. Mm-hmm. And if you're going to appear in court, you need to be licensed to appear as an attorney. And that's generally done on a state-by-state basis. But there's a hefty trade of attorneys who appear in other states on behalf of their clients. And that's a process known as pro hac vice, basically, for this case. And the practice has become more formalized than it used to be. Mm-hmm. It used to be you would file a motion, very plain vanilla motion, no additional documents required in the court where you wanted to appear, and generally the court would grant it and you would be permitted to appear before that court for that particular case.
So you don't have to be licensed in the state.
Yeah, it was not a license to practice law in that state. It was permission to appear before that court for that particular case, to act like a lawyer. Then my theory has been that the organized state bars and the regulatory authorities figured out that they could make money on the process. So many states now, you have to file a more formalized pro hac vice application. You have to obtain a certificate from the regulatory authority acknowledging that you have registered to appear pro hac vice. You have to, of course, present a certificate of good standing from the state in which you are admitted. In other words, a certificate that says, yeah, you really are licensed to practice law in your home jurisdiction. You have to pay a fee. In Texas, the fee's about $500. It's expensive.
Okay, yeah.
And then you file all that paperwork, and you can get admitted to practice in that particular case. The one thing that process does is it gives the regulatory authorities a better feel on how frequently someone is actually appearing pro hac vice in that state.
Do they have a limit?
Some states have a limit that says if you hit this many times, then you need to get a law license here. Others have less formal limits in the sense of they don't have a numerical limit. But if a party is opposed to your pro hac vice appearance, then they'll start arguing about how many times you have appeared, and that effectively to make the argument that you're really practicing law in that state on a regular basis, and you should go get a law license.
Right.
Now, unlike medicine, where there is a process to get licensed in other states which is not particularly onerous, law continues to have a large number of barriers to entry. It takes time to get licensed in another state.
Right.
There are application fees. There are states where have what are called reciprocity, which means you can get licensed in those states meeting a smaller number of criteria if your home state uses that reduced set of criteria for people from the state that you're trying to get into. So, and some states have little to no reciprocity. And a number of states forever have had residence requirements saying that, yeah, you can't even get admitted here unless you live here or unless you work here full-time in an office. And that was always a gigantic barrier to entry
Right.
to actually get a license to practice law in that state. The collateral issues that arise as you get licensed in more jurisdictions are many. You have multiple regulatory authorities. You have multiple requirements for maintaining your license. Mostly they overlap. Most of them are just CLE requirements, but not all CLE is accredited in all
CLE?
states. Yeah, continuing legal education. For example, in Texas, we're required to have 15 hours a year of continuing legal education. And a number of other states have.
What does that mean, continuing legal education?
It's kind of like continuing adult education. It means that you have to spend 15 hours a year either sitting in an in-person presentation, watching a webcast, or listening to audio of people updating you on the law effectively. And on the many components or areas of the law. So Texas has a number of providers of CLE, and they run the whole gamut from trial work.
Do you have to
through
pay for these
office work.
programs?
Yes and no.
Okay.
You have to pay for the majority of the providers, but the State Bar of Texas on its website provides like one free hour per month of CLE. And so
okay.
you can come pretty close to fulfilling all of it that way.
Oh, okay.
If you're a member of a local bar association, then that bar association frequently will have CLE presentations, and you can attend those for free, but you've paid up front to be a member of that local bar.
Right.
For example, the Dallas Bar Association has a very active CLE program. More and more in person now, some hybrid, some online. For a while during the pandemic, it was almost all online.
Right.
But
yeah.
it gives you an opportunity to take as many of those courses as you want without having to pay additional. And then there are providers of free legal services who provide CLE in sort of a quid pro quo fashion. In a, we will teach you how to do, for example, simple divorces, and we won't charge you to take the course, but you have to promise us that after you take the course, that you'll agree to accept 1 or 2 or 3 of these cases for free from legal aid. So you're not paying for it in the sense of cash up front.
You're paying with your
You're
time.
paying with your time afterwards.
Right.
So it's out there. And if you're in multiple states, I had an attorney that was working for me. He was licensed in 4 or 5 different states. And so it was a lot of work, actually, for him to keep up on.
Yeah, I can only imagine.
Is this good for CLE in Minnesota? Is this good for CLE in Iowa? Is this good for CLE in Texas? Is this good for CLE in Wisconsin? Is this good for CLE in Nebraska? I think I've hit all the states where he was licensed. It's quite a few.
Have you ever been licensed in different states?
No, I've only ever been licensed in Texas.
Gotcha.
I've appeared pro hoc vice in a number of states, but it's a state-by-state, case-by-case process. So we've talked before about filing pleadings with a court, and if you're coming in from out of state, if you're going to be the counsel, even the lead counsel, you have to tell the court somehow. And some people do this by coming in and saying, hey, we'll file the original pleading in the case. We'll have the name of the local counsel, and we'll put our name in there. And then we'll put pro hoc vice to come, pro hoc vice pending, pro hoc vice application in process. We'll use some language like that to accomplish two things. One is tell the court that we are going to be in this case. And two is tell the court, well, we know about that pro hoc vice process, and we're going through it.
And is that because the client just prefers a certain lawyer, so they make that accommodation?
Yes, yeah. It often is, and sometimes it deals with subject matter expertise of the lawyer that you want to bring in from out of state.
So does the lawyer have to study up on all the different laws within that state?
Yes and no. The short answer is no, not in the way that you would normally think. But in coming in, you are in a lawsuit. You are following that state's procedures. You're following that state's evidence rules, and generally, depending on the case, you're following that state's substantive law. So there's a lot of work that goes into appearing pro hoc vice. A lot of, and particularly in the procedural part, because how the different state court systems go about doing things is about 80% the same and about 20% different. And that 20% can kill you if you don't know about it correctly.
Right, yeah.
So you have
So do you usually work with a lawyer within the state, or you can work independently no matter what?
usually with a lawyer within the state.
Okay, that makes sense.
Your local counsel, who you hope the goal is that they keep you out of trouble.
Yes, yes.
So yeah, you can do that, but not that way. You have to do it this other way.
Oh, that's good, that's good.
But one of the things that has cropped up in recent Texas cases in the last couple of years is whether putting your name on a pleading and saying pro hoc vice application to come or pending is itself the unauthorized practice of law. From the theoretical construct of here's a piece of paper filed with a court, and here's my name on that piece of paper, and under my name it says that I'm the attorney for one of these parties in this case. And previously, for a long time, you could do that pro hoc vice pending, and nobody really thought twice about it. But there's a couple of recent Texas cases that suggest that is a basis, that if the trial court decides it does not want to allow you to come in and practice just for that case, then the fact that you have appeared on the pleadings, even saying that you're admitted in state X, and that you've got a pro hoc vice application pending or to come, is enough over the line of practicing law that a court of appeals will say, it's within the discretion of the trial court to say no to you, precisely because you have put that on the pleadings.
Oh, interesting.
Yeah, so it's just an intriguing. Be very careful about what you do and about what the unauthorized practice of law is.
Yeah.
And appearing pro hoc vice is different from being licensed in the state. If I'm licensed in the state, I can go into court on behalf of a client. Judge may be annoyed with me. Judge may not like me, but judge can't say, no, you cannot appear in my court on behalf of that client. The license gives you a right to appear in the court on behalf of that client.
Right.
And the client has a right to choose the attorney whom they want to represent them in general. Pro hoc vice is very different. Pro hoc vice is discretionary with the court.
Yeah.
Meaning that a court can decide that it wants to admit you. It can decide that it does not want to admit you.
What are the reasons that the court wouldn't want to admit a lawyer?
Sometimes they don't want to admit the lawyer because the lawyer has appeared too many times in the state, even in states without a numerical limit. if you start hitting 6, 7, 8 times in the last 2 or 3 years, then judges can look askance at that and say, no, you really need to get a license instead of continuing to do it this way.
How long does a license usually take in another state?
It depends on the state, but sort of backhand math is about 9 months to a year. So it takes time. It takes money. It just takes a lot of paperwork. So,
Yeah.
and it's one more state in which you then have to pay bar dues.
Oh,
So,
yeah.
And or occupation tax.
Why do
depending
you
on the
have to
state.
pay, after your lawyer, why do you have to pay the bar tax?
You pay bar dues to support the cost to the state of operating the regulatory body that governs attorneys.
Oh, okay.
That's the primary reason for it.
Mhm.
The courts have very much restricted the requirement that you pay a regulatory authority to being the amount that is necessary or the amount that's used by the regulatory authority in its core function of regulation.
Mhm.
You cannot, as the Bar Association in a mandatory bar like Texas, collect mandatory bar dues and spend any substantial portion of that on essentially non-regulatory activities, which have been challenged in some states. Like if your bar runs an Instagram account, for example, and puts out a Happy Cinco de Mayo post, you would think, oh, that's innocuous. Well, maybe it's not innocuous to everybody. And how do you, as the bar, say, well, I incurred some expense doing that. How is that related to my regulatory function? And the answer is it's probably not. So the Texas bar in the last year has significantly reduced the anything that could stray out of its lane of spending money on actual regulatory items. Now that's still a large amount that the bar can do, but it cuts short of such things as advocacy of legislation, and it cuts short of getting involved in any political issues. It cuts short of getting involved in any social issues. So it's very much your job, and what you can require people to pay you for as lawyers is to make sure that the people who are practicing law in the state are of good character and are following the ethical rules. And if they're coming in as new attorneys, that they pass the bar exam and exhibit some minimum indicia of knowledge of the law and functional competence in order to be given a law license.
That makes sense, yeah.
So anyway, back.
I can get sidetracked with my little questions.
Yeah. They're good questions. They all are. So, but back on the pro hoc vice, it's a developing world of what are reasons that people can kick you out. The reason for denying a pro hoc vice can, as I said, it can be because you appeared too many times.
Right.
In the opinion of the judge. It can sometimes be what are you going to add that we don't already have here? Because when I look at your side of the courtroom, I already see 6 attorneys. And do I really need another talking head to talk to me in this case? Other times it can be you have not been suspended or disbarred. in your home state. But you've got enough things pending against you that I don't think it would be appropriate to allow you to practice here in this court at this time.
Interesting, yeah.
So that's the whole discretionary part of it. And now you've got this overlay of, really? You put your name on a pleading and you tell the judge, I'm not admitted, but I'm going through the process, but I want you to know that my plan is to be in this case. Is that enough for a court to say, I see an authorized practice of law, and within my discretion, which will be upheld by the Court of Appeals, I'm not going to allow you to appear. So, and it's a very different world of appearing only through the permission of the court, as opposed to having a right to appear because you have an actual functional law license in that state. So that's a whole explanation of prohibition.
And this can be implemented at any level of court?
It can. You see it most frequently in the trial court system. In the, you see it in, let me divide up state and federal too. In the state court system, you still have the same sort of pro hoc vice criterion requirements. You see it much more in the trial court than you do on appeal, but you do see it a fair number of times on appeal. My sort of impression, anecdotal, is that generally by the time you get to the Court of Appeals, they're a little bit more liberal of, you can come in and argue, you can come in and brief. There's plenty for you to do here. Federal courts are different because federal courts have separate regulatory authority over who is authorized to practice law in front of them. For example, if you get licensed by the State Bar of Texas and you then march off and say, I'm going to a federal court in Texas and I get to practice here, the answer is probably, but first you have to file an application to actually get admitted to practice here in the court. In Texas,
there's a lot of regulation on that.
Yes. Well, either to protect the public, to assure the smooth functioning of the courts, or to erect barriers to entry into competition. Take your pick.
Debatable.
But the federal courts have their own admissions procedures. They're not particularly onerous. You have to file an application that effectively says, here's my proof that I really am licensed, for example, in the state of Texas, and there's nothing bad about me, and so let me in.
Okay, this is like a super basic question, but it just occurred to me. Do you have a physical license, or is this like they give you a number, they give you like some sort of documentation? It like never occurred to me up until just now.
You get a physical law license. You get a law license that is, it's a little bit larger than an 8.5 by 11 piece of paper.
Oh, okay.
It's a reasonable size. It's issued by the clerk of the Supreme Court of Texas. You're supposed to take your lawyer's oath, and on the back of it, you can endorse when and where the lawyer's oath was taken. Most lawyers get that. They hang it in their office as wallpaper for the remainder of their career.
They get that after they pass the bar?
Yeah, after they pass the bar, not before.
Yeah.
So you get your piece of paper. Like if you pass the bar and you go down to Austin for the big swearing-in ceremony. You can be sworn in by any judge, but lots of people like to go to Austin and be there in the ceremony and see all the judges from the Texas Supreme Court, from the Court of Criminal Appeals. So you got 18 judges sitting up there. And
Very
then,
official.
Yeah, and then they do this mass swearing in, and then the clerk's office of the Texas Supreme Court is handing out the actual law licenses, and people take them, they unroll them, and take photographs with all their family members who came.
Yeah.
And then they go and they get it framed, they hang it in their office like I'm a lawyer. One lesser known aspect of those law licenses is that if you get disbarred, if you're unable to maintain your license and you lose it through disciplinary proceedings, or you lose it because you fail to pay your bar dues, or you lose it because you fail to complete your continuing legal education requirement. And the last two, you really have to mess up to ultimately lose the license.
Right.
But in disciplinary proceedings, every year there are a number of lawyers, not a great number, but there are lawyers who end up being disbarred.
Mm-hmm.
When you are disbarred, you are required to return the physical law license.
Wow.
Because this is...
You can't say you lost it.
You can say you lost it. You can
Yeah.
account for it by saying, I lost it, and I promise you I really don't have it. But that license, it's a piece of paper. It's sort of one of these, know all people buy these presents. Or
Yeah.
actually, I think they still say know all men buy these presents. But it's like you can walk around like, I got a license to practice law, just like
Yeah.
I've got a driver's license.
Yeah.
So you have that license, and you have to turn it in if you wind up getting
crazy.
disbarred.
Is that public record?
Yes, yeah, that's all public record. Whether you're admitted, whether you're not admitted, whether you've been disbarred or not is all public record.
Gotcha.
So the other thing that you get though is, you get one of these.
She's gold. I love gold.
Yes, gold. You actually get this little State Bar of Texas card. So, and it recites on the back, the person named hereon is enrolled as an attorney by the Supreme Court of Texas. So then it goes on to say non-payment of annual fees, failure to comply with MCLE requirements, suspension, disbarment, or resignation automatically revokes this card.
They're threatening you.
Whereupon it must be immediately surrendered to the clerk of the Supreme Court of Texas.
Wow.
So I've had these. You get this card, and
You only get one.
you carry it around forever, and you think, what am I ever going to do with this card?
Mm-hmm.
And mostly there's not a lot that you do with it, but there are a few specific instances where you are in fact going to need that card and where you are going to use it.
Mm-hmm.
And one is going in and out of jail to meet a client, going in and out of the Texas Department of Corrections to meet with a client. You need to present your bar card at almost all of those facilities, along with your photo ID, your driver's license, and they generally hang on to them until you leave the facility. So you have that. And then you've got the other place that it has been useful for me is not in Texas. You don't get to take your bar card out and say, I need to skip the security line at the courthouse. But I did a case in Massachusetts, pro hoc vice, and going through the security line, and they use, at that courthouse, they used a separate security line for lawyers. And so
Did you feel special?
state trooper comes along. He's like, are you a lawyer? I'm like, yeah. He said, can I see your bar card? And I'm like, yeah, I got it right. He said, well, you need to go over in this line. I'm like, great. So I go over to the other line and go through security.
The fast lane TSA almost.
Yeah, and that has been getting through those courthouse security lines, or they're quicker now than they were for a long time. But none of the please let us bypass security proposals have ever made it to the point where they're fully functional in Texas, because lawyers have pushed, and the state bar has pushed quite a bit on, hey, if they're a licensed lawyer, then do we really need them to go through the full-blown security at some of these courthouses?
Yeah.
And despite everybody talking about it, despite a number of concrete proposals, it's never actually happened. So it's just intriguing. So yes, to answer your question, you get a piece of paper.
And can I ask you one more question
Sure.
that's more like personal, but where did you get sworn in?
I got sworn in Austin. I went to
nice.
the large ceremony. So,
Do you have a photo?
No.
Oh.
I don't think I've got a photo. No.
Okay. Well, when I get sworn in, I'll make sure to, have you there.
Take lots of photos.
Yes.
And they do this it also sort of depends on the firm where you're at. When I was at the big firm, we would have 30, 35 first years, and they would all pass the bar together because all the results came out on the same day. So we would just round them all up in cars, haul them down to the courthouse.
Oh, that's hilarious.
Find a judge and get them all sworn in.
Yeah.
Which sounds hilarious, but the real driver,
Yeah.
aside from, it's a nice social event, congratulations to almost all of you, because every year, every other year, out of the 30 to 35, there would be one, maybe two, who didn't quite make it through on that first time. So,
Oh, no.
of course, they're feeling terrible, and
Yeah.
you go talk to them, and you're like, don't worry. You get another shot at it 6 months from now. And
Is there a limit to how many times that you can take the bar?
there is, in Texas, you can, see if I didn't prepare for this one. Texas, you can take it twice, if I recall right, without additional legal education.
Oh, interesting.
And then I think they still require some form of additional legal education before you take it beyond those 2 times. So there are multiple people who take it multiple times. So the real reason that you want to run all your associates down immediately is because most of your engagement letters for hourly rate clients have one rate for law clerks and another rate for first-year associates, which is higher.
So you're going to be losing money if you don't do it.
You can't bill them as an actual attorney until they've completed that final step of being sworn in.
Yeah.
So you get them sworn in right away. So, there you go. Hourly rate goes up
That's so
just like
funny.
that.
Yeah.
So that works reasonably well. So that's good.
Yeah. And going back to the Elon Musk case, can you fill me in on how this is applicable?
Well, the Elon Musk case, when he had his deposition taken, he had an attorney who had appeared on the pleadings right before the deposition that had noted that it was pro hoc vice pending. And now that pro hoc application is being opposed in the trial court on the basis that he did exactly what I just described, that he put in that he had a pro hoc application pending, and they hauled up these 2 2022 roughly vintage cases in Texas that said that gives the trial court the discretion to go, no, that was the unauthorized practice of law, so you can't come in. Only those with the purest of heart and motive can appear before this court. so there's that little aspect to it that is just sort of a procedural twist. And really, but for those recent cases, I would not have thought twice about people appearing with a clear designation that they're pro hoc. From time to time, you run across a pleading where you look down and the out-of-state attorney has just frickin' signed their name. They've never done the pro hoc. And there's nothing on there to indicate that they're appearing pro hoc vice or plan to file an application.
Right.
And in those instances, they need to, I personally think that creates more trouble for them. That's more like, I'm here and I'm representing them, judge. What is this pro hoc you speak of? Even if they're going through the same steps and getting it done. And one thing that it accelerates is people actually getting it done on a timely basis. I've seen a number of people who will file pleadings, and then sort of the weeks and months go by, and you're talking to the out-of-state counsel, like, you need to get your pro hoc done.
Yeah.
And they're like, yeah. And then you finally get an in-person hearing. You finally get, or a Zoom hearing. You finally get something where they plan to appear in person, talking to the judge, part of a hearing in the case.
Right.
And then that seems to be the impetus, like, I need to get that pro hoc done. It's like,
Yes.
dude, you need to get the pro hoc done from the very beginning when you first appeared in the case. But you better.
Because how long does that take? Did you already mention that?
You can get that done in less than a month.
Okay.
It's not that onerous. You have to get your certificate of good standing from your home state. You've got to file the papers with the regulatory authority here in Texas. You've got to pay I think it's now a $500 fee. You have to get the certificate from them that they've received your application, that you've paid the fee, and that they've confirmed that you're eligible to appear pro hoc vice. Mm-hmm. After that, you then have to file that with the local court, along with your local counsel vouching for you, saying he or she is a good person and will do just fine in this case. And then you present that to the judge and it gets signed, you hope.
Yeah.
A lot of them get signed pretty routinely, pretty quickly when they get filed. Sometimes there's a hearing. Often, I think in the great majority of cases, there's actually no opposition to people appearing that way.
That's so interesting that they decided to oppose it. And what do you think, like, the legal team for Elon Musk, what are they thinking? What do you think that is the next step for them? They just have to accept it?
They're just, you just go ahead and complete the application process, and you
Okay.
have the hearing in front of the judge. And the judge can, because it's discretionary, the judge can say, yeah, I'm not impressed with those reasons for keeping them out, so I'm going to let them in. Mm-hmm. Or you can say, okay, well, that's enough to support a decision that I don't want somebody in.
Right.
The country as a whole has a very strong bias towards allowing people their selection of counsel, allowing people to be represented by the attorneys whom they want to be represented by. And that is the sort of the real driver, I think, of pro hoc. As long as you've got somebody who otherwise meets the criteria, even though they're licensed in another state, if the client wants them here in this state, in this particular case, and they're not otherwise engaged in the regular practice of law within the state, then it makes sense to allow them to appear. Because when you say no, it's not just saying no to the lawyer to say, you can't appear in this particular case. It's also saying no to the litigant, saying, I will not let you have this out-of-state lawyer be part of your legal team or represent you in the proceedings in front of this court.
When you say litigant, does that mean client?
Yes. Well,
Gotcha.
it's the lawyer's client. The litigant is just one of the parties to the lawsuit. And that is... that for many clients is, and that's really sort of what you're looking at in terms of, should you have a pro hoc, and if you got somebody qualified, why not let them in, particularly if the client wants them. So, but that's now the federal courts. They're different. Like in Texas, you've got 4 different federal district courts, northern, southern, eastern, and western. And you have to file an application in each one. You have to get admitted separately by each one. And they all have their little slightly different criteria for getting admitted. The western district has an education component that the other districts, I think, currently do not have. And that education component is you need to do about 4 or 5 hours of CLE on. Our courts are different from state court. we have a set of different rules called the Federal Rules of Civil Procedure. You're not following the Texas Rules of Civil Procedure here. So we do things a little bit differently, and we would like to have some minimum assurance that you realize and understand how things are done differently over here in federal court as opposed to 2 blocks away at the state courthouse. Yeah. Now, some federal courts have what I would call a 2-tier bar practice, which is Texas does not in any of the 4 districts. But some federal courts say if you are going to appear in a trial, then we're going to require a demonstration of some minimum amount of trial experience before you can appear first chair in a trial here in our federal district. Yeah. And so typically those are like, you must demonstrate 2 or 3 trial experiences where you have been there sort of as second chair for a trial.
Is that common language? The first chair, second chair?
Yes, yes.
Oh, interesting. I didn't know that.
Right.
I used to play viola, so I understand that.
You understand? Yeah.
I was like, interesting. Lawyers use that too. Yeah.
Yeah, we do that all the time in trial work. It's like if you're really the one that's captaining the whole case as it gets presented in court, then yeah, you're first chair, and you get to sit right there at the end of the table, right next to the microphone. The judge is always looking at you, and then second chair is like your assistant for doing absolutely everything. And
Are
then,
paralegals ever in the court with you?
yes, they come to most trials. Most trials of any size, you bring your legal assistant. You need somebody to keep you organized more than anything else. Keep the exhibits flowing. Go out and make phone calls that maybe need to be done during trial.
Yeah.
Go out in the hallway and tell the witnesses who have been subpoenaed, who are waiting to come on, that the testimony before them is running longer, and that you do not yet have them ready to, their turn to come in and testify. That's not yet happened. So they perform a variety of functions. And then you get larger trials, and you've got like a third chair. So then you've kind of filled up the table.
Yeah.
So, sometimes I've been in hearings, and you've got 12, 14 lawyers and support personnel on one side or the other side.
How do they fit so many lawyers?
By taking up a bunch of the seats in the courtroom. We did a 2-day pretrial hearing in the case, and I think there were 5 attorneys. 5 attorneys grouped around the table on the other side. 2 associates who were sitting in the first row of the audience seating, and then 2 consecutive rows of where each row had 3 legal assistants or 3 support personnel there.
Yeah.
It was
That's a robust team.
It was a big case. It was a robust team.
Wow.
And we had a pretty comparable grouping on that side. And it worked reasonably well for everybody.
Well, maybe I look forward to maybe joining you in court one day just to see and observe. I'd love to see something like that.
Yeah, you're welcome to come.
Okay, awesome.
Courts are public. One of the things that people don't do enough of, I think, is come down and see the court in person. It helps. Although I will say we get so used to the fact that the courtrooms are empty during a lot of civil trials. There just aren't a lot of people in the audience. There may be 1 or 2 or 3 on each side.
So anyone can just show up to court and open the door, and are any type restricted?
No. It's the courts are public in this country.
Period.
So, there are certain exceptions where some parts of some proceedings can be closed, but they're far and few between. Cases involving trade secrets, they can sometimes close the courtroom, and there's certain other types of cases, but mostly it's all public.
Interesting.
So, but we get so used to the fact that when you're trying a case and you've been there for a couple of days, you look around, you know who everybody is in the audience. When somebody walks in, you don't know who they are.
Yeah.
You're thinking, well, who's that person? Are they with the other side or not?
Yeah.
And often, when you get to the next break, you're like, I'm just curious. And you just go back and say, hi, how you doing? You enjoying the trial? Who are you? Why are you here?
Yeah, they're completely unrelated. That's hilarious.
Yeah.
Well, there you go, listeners. If you are interested in getting that firsthand experience like I am, just go to court. Just go to any room and absorb whatever knowledge you can get from there. But anyways, that pretty much wraps up this episode, really covering about pro hoc vice. I think I didn't know about it, so I'm really fortunate to get educated along with you. But as a reminder, of course, please check out our podcast and subscribe wherever you get your podcasts, and follow us at SMQ Law. Thank you so much. Would you like to add anything?
No, I think that's it.
Perfect.
That covers just about all of it. But do be sure along the way that you You get your local lawyer who's licensed in that jurisdiction and is competent
Yes.
and versed in the intricacies of the local procedures, because a lot of law can be very local when it comes to procedure, be it individual by state or individual by county and individual by that particular judge. So
Yes.
when you're going to court, it always helps to have somebody who's been there before in that county and who's been there before in front of that particular judge.
Yes. Excellent. Thank you so
That's
much. And we will see you next episode.